Hey guys, today we are going to talk about estoppel by convention. This is a distinct form of estoppel from promissory estoppel. Now, the Court of Appeal in Singapore, in Singapore Island Country Club and Hilburn, laid down three criteria for establishing an estoppel by convention. First, there has to be a cause of dealing between the two parties in a contractual relationship. There has to be a contract. Number two, the cause of dealing must be such that both parties must have proceeded on the basis of an agreed interpretation of the contract. Third, it must be unjust, that means unfair, to allow one party to go back on the agreed interpretation. The Singapore High Court, in another case of Panwell and Indian Bank, also stated that estoppel by convention was founded on an agreed statement of facts, the truth of which had been assumed by the convention of the parties as the basis of a transaction into which they were about to enter. Therefore, as regards the transaction, each was estopped as against the other from questioning the truth of the statement of facts so assumed. I'm going to discuss one of my cases where this doctrine of estoppel by convention was argued. Some of you may have watched the video on promissory estoppel, but if you did not, then I'll give you the brief facts of the case. Basically, it was a landlord and tenant dispute. The landlord had entered into 4 tenancy agreements with the tenant, who was my client. Each of the 4 tenancy agreements contained an option to renew clause. During the first 3 tenancy agreements, the exercise of the option to renew was done by email through the real estate agent. And during the 4th tenancy agreement, even though there was an option to renew clause, unconditional right of the tenant, my client, to renew under the option to renew clause, the landlord refused to grant a renewal. And when I sued her for specific performance or damages in lieu of specific performance, her sole defense was that the renewal notice was not sent by registered post. Her lawyer went through the tenancy agreement. At the bottom of the tenancy agreement, he spotted a clause to the effect that all notices shall be sufficiently served if sent by registered post to the address of the landlord or the tenant. So to recap, during the 8 years, 4 tenancy agreements, all correspondences and notices to renew were sent by email or text message through the real estate agent. And during the 4th renewal of the tenancy, the landlord refused to renew the tenancy agreement because on the basis that it was not sent by registered post under the contract. So one of the grounds that I argued was that an estoppel by convention arises based on the facts because of the previous course of dealings between the landlord and the tenant over 8 years. There was a shared assumption or agreed interpretation under the tenancy agreements that all notices and communications were to be made between the landlord and the tenant via the real estate agent, whether by emails, text message, or voice calls. So my client, the tenant, proceeded on the basis of this agreed interpretation of the contract and gave notice to renew under the 4th tenancy agreement by email to the real estate agent. And therefore, it will be unjust, it will be unfair for the landlord to now go back on the agreed interpretation and not grant my client the renewed term of an additional 2 years. So I took out Order 14 summary judgment, and this was one of the arguments made. I won, and we got damages in lieu of specific performance. Thanks for watching this video. Don't forget to click like and subscribe.